This lecture explains the nature of the agreement that forms the basis of a contract. Through a talk on offer and acceptance, we're going to see how promises become legally binding. This lecture also contrasts non-offer situations. Responses to the offer and which acts terminated are defined and discussed. Essential to any contracts is an agreement. An offer must be made and it must be accepted. The parties must manifest their assent to the same bargain. Once agreement is reached, if the other essential element of a contract is present, consideration, capacity, and legality, a valid contract is formed, generally creating enforceable rights and duties between the parties. An offer is a promise to do or refrain from doing something in the future. The elements necessary for an effective offer include a serious intent by the offeror, reasonably certain or definitive terms so that they can be ascertained by the parties in accord, and communication of the offer to the offeree. Serious intent is determined by what a reasonable person in the offeree's position would conclude the offerer's words and actions meant. Offers made in obvious anger, jest, or undue excitement do not meet this test. Expressions of opinion is not an offer. For example, a doctor's opinion that a hand will heal within a few days of an operation is not an offer. Preliminary negotiations. A request or invitation to negotiate is not an offer. This includes statements such as, "Will you sell your estate?" and "I wouldn't sell my car for less than $1,000. An invitation to submit bids is not an offer. Thus, when contractors are invited to bid on a job, the party to whom the bid is submitted is not bound. The bid is an offer, however, and the contractor is bound by its acceptance. Advertisements. In general, ads, catalogs, price lists, and circular letters are treated as invitations to negotiate. If an ad to sell a single item was interpreted as an offer and 50 people accepted, the offerer would breach 49 contracts. A price list is not an offer to sell at that price. It invites the buyer to offer to buy at that price. If an ad makes a promise so definite in character that it is apparent that the offeror is binding himself or herself to the conditions stated, the ad is treated as an offer. Thus, an ad may be an offer if it solicits performance, for example, by offering a reward. In an auction, goods are made available for sale through an auctioneer. An auction is not an offer. The owner is only expressing a willingness to sell. In an auction with reserve, the owner may withdraw the goods at any time before the auctioneer closes the sale. An auction is assumed to be with reserve unless it is stated to be without reserve, in which case the goods cannot be withdrawn and must be sold to the highest bidder. Online auctions are offers to sell items such as eBay and other sites. They're treated as invitations to negotiate. The second requirement for an effective offer concerns definiteness of its terms. A contract must have reasonably definitive terms so that a court can determine if a breach has occurred and can give an appropriate remedy. An offer may invite an acceptance to be worded in specific terms so that the contract is made definite. For example, an offer may specify that a quantity be stated in acceptance. If the quantity is not so specified, there may be no enforceable contract. An offer must be communicated to the offeree so that the offeree knows it. Ordinarily, one cannot agree to a bargain without knowing that it even exists. An offeree can transform an offer into a contract by acceptance. This power of acceptance can be terminated, however, by action of the parties or operation of law. An offer may be revoked any time before acceptance, even if the offeror agreed to hold it open. Revocation can be by express repudiation or implied by conduct inconsistent with the offer. Revocation is effective only on receipt. Revocation of an offer made to the general public must be communicated in the same manner in which the offer was communicated. Irrevocable offers, detrimental reliance on an offer by the offeree, can make the offer irrevocable. Another form of a revocable offer is an option contract, which is created when an offeror promises to hold an offer open for a specific period of time in return for a payment by the offeree. An offeree may reject an offer. A subsequent attempt to accept constitutes a new offer. Rejection is effective only on receipt. Asking about an offer is not a rejection. A counteroffer is a rejection and is simultaneously making a new offer. The mirror image rule requires that the offeree's acceptance match the offeror's offer. Any material change in the terms automatically terminates the offer and substitutes a counteroffer. An offer terminates automatically when the time specified in the offer has passed. The specified time begins to run when the offeree receives the offer, not when it is sent. If the offer is delayed, the period begins to run from the date the offeree would have received it, but only if the offeree knows or should know of the delay. If no time is specified, the offer terminates at the end of a reasonable period, as determined by the subject matter of the contract, business and market conditions, and other relevant circumstances. An offer terminates if the subject matter is destroyed before the offer is accepted. An offer terminates if the offeror or the offeree dies or becomes incompetent. This rule applies whether or not the other party had notice of the death or incompetence. A statute or court decision that makes an offer illegal automatically terminates the offer. Acceptance is a voluntary act, either by words or conduct, by the offeree that shows assent or agreement to the terms of an offer. An offer must be accepted by the offeree, not by a third party, except in certain special circumstances. Only the person to whom the offer is made, or the person's agent, can accept it. The acceptance must be unequivocal. Unequivocal acceptance is required by the mirror image rule. An acceptance subject to new conditions or with terms that materially change the offer may be considered a counteroffer. In most situations, the acceptance must be communicated to the offeror. In a unilateral contract, no communication of acceptance is generally necessary because acceptance is evident. Notice is necessary if the offeror requests it or has no adequate means of determining whether there has been performance. In a bilateral contract, communication of acceptance is necessary because acceptance is in the form of a promise, and the contract is formed when the promise is made. Communication is not necessary if the offer dispenses with it or the offer can be accepted by silence. Acceptance must be timely, and acceptance is timely if it is made before the offer is terminated. The mailbox rule. Acceptance is effective when it is sent by whatever means is authorized by the offeror. This is the mailbox rule. The authorized means of acceptance, specific means can be stated in the offer or authorized by facts or by law. If an offeror specifies an exclusive means, the contract is not formed unless the offeree uses it. If the offeror does not specify a certain means, the offeree can accept by any medium reasonable under the circumstances. A medium is reasonable if it is the same means as the offeror used to communicate the offer, or a faster means. Substitute method would be where an acceptance sent by an authorized means is effective on receipt. E-contracts offer an acceptance. A contract entered into online has the same basic requirements as a paper contract. Disputes arising from contracts entered into online concern the terms and assent to those terms. Terms should be conspicuous and clearly spelled out. On a website, this can be done with a link to a separate page that contains the details. Subjects that should be covered include the acceptance of terms, a mechanism by which an offeree can affirmatively indicate consent, such as an I agree box to click on, the payment including taxes, refund and return policies, disclaimers, limitation of remedies, and dispute resolutions. A shrink wrap agreement is an agreement whose terms are expressed inside a box in which computer hardware or software is packaged. In most cases, the agreement is not between a seller and a buyer, but between a manufacturer and the user of the product. The terms generally concern warranties, remedies, and other issues associated with the use of the product. A shrink wrap agreement is enforceable if the terms are conspicuous and accessible, and the buyer had the ability to read them before using the product. Once the product is used, the terms are binding. A click-on agreement occurs when a buyer completing a transaction on a computer is required to indicate his or her assent to be bound by the terms of an offer by clicking on a button that says, for example, I agree. The buyer does not actually have to read the terms to be bound. The Uniform Electronic Transactions Act applies to some e-contracts. The UETA does not create new rules for e-contracts, but supports their enforcement. The UETA does not apply unless both parties to a transaction agree to conduct it by electronic means. In this scenario, would a reasonable person conclude that Julio's statement was a serious offer? In this example, Julio is frustrated. Julio has had a bad day, the car is not working, and Julio's frustrated. They are riding to school one day, Debbie and Julio. And Julio's automobile has a market value of $12,000. One cold morning, they get into the car, but Julio can't get it started. And he yells in anger, I'll sell this car to anyone for $500. Debbie writes a check for $500 and drops it in his lap. Well, is this a serious offer? No, it's not. A reasonable person, taking into consideration Julio's frustration and the obvious difference between the car's market price and the purchase price, would really conclude that His offer was not made with serious intent. Thus, even if Debbie dropped $500 in Julio's lap at the moment of his angry offer, she and Julio would not have had an agreement. This covers the lecture of offer and acceptance.